Brian Smith, Compliance Podcast for October 2021. Great to talk to you again, Brian. How are you today?
I'm doing great. How are you doing?
I'm good, man. It seems like for the last 5 or 6 months, we've been talking a lot about the government loan programs and all the different functions that they've been doing. So we're shifting gears just a little bit today. That's exciting.
Yeah, that stuff is old news.
The today's topic, what we're really going to be focusing on, is that federal protection for tipped employees and how the Department of Labor has modified the 2020 tip final rule. I'm kind of excited about this because I know there's been some pretty big updates. So I'm really curious to find out what you've uncovered in your research. Without further ado, man, let's jump in. I understand some of the updates were announced here recently by that Department of Labor regarding the protections for tipped employees. Let's get some context as to what this means and what the updates that were announced, what's going on.
You bet. So to start off, the Consolidated Appropriations Act of 2018, which was enacted on March 23rd of 2018, that law amended the Fair Labor Standards Act, or the FLSA, to allow the Department of Labor to impose civil money penalties when employers keep employees' tips, regardless of whether the violations were repeated or willful. But the Department of Labor published legal authority to the contrary. The 2020 tip final rule allowed the civil money penalties to be applied only when the violation was repeated or willful. Now, the 2020 tip final rule was initially scheduled to go into effect on March 1st, 2021. However, once the new administration took over, the Department of Labor delayed the effective date to April 30th of 2021, and then ultimately delayed the effective date until the end of this year, December 31st.
People who know me well, Brian, would often say I'm a contrarian, but I don't know. I don't know how the Department of Labor is able to create something, a final tip rule that has contrary views. Explain this to me. Talk me through this.
Well, the Consolidated Appropriations Act granted statutory authority to the Department of Labor to create that 2020 tip final rule as they determined to be appropriate. So, in my opinion, the law was interpreted in an unusual way.
Interesting. Okay, so kind of a unique spin on that. Any other tip protections that we should highlight, especially as they pertain to that Consolidated Appropriations Act that was enacted in, what'd you say, 2018?
Yes, sir.
Yeah.
Yeah, there was one other that I would like to mention. The Act expressly prohibits employers, owners, from keeping employees' tips for any purpose, regardless of whether or not the employer takes a tip credit. And the Act also prohibits employers from allowing managers or supervisors to keep any portion of employees' tips or participate in a tip pool.
So no managers, no supervisors to be able to retain or keep any tips or earn those as a portion of the tip pool. Okay, that's interesting. Now, these changes were recently announced, or how recently did these come out?
No, so the 2020 tip final rule is the set of rules that were just updated by the Department of Labor. But remember, the 2020 tip final rule, it was delayed until December 31st,
This year,
2021, so it actually hasn't taken effect.
Okay, so what were the updates if those were kind of old rules that they updated, or it didn't announce those ones recently? What were the updates that just were recently announced?
Good question. So after the Department of Labor's normal rulemaking and comment period, they have decided to withdraw the provisions in the 2020 tip final rule that allowed the department to assess those civil money penalties only for violations that were repeated or willful.
Okay.
So they withdrew those. So in the case of an employer, manager, or supervisor keeping an employee's tips or participating in a tip pool, the Department of Labor will be able to assess civil money penalties for first-time violations, for a first-time violation that was not willful. You know, the fines are up to $1,162 per violation. And of course, the fine for a repeated or willful violation is more than that. It's $2,074 for each violation. And in addition to the penalty for the violation, the tips withheld plus an equal amount. So if I withheld $100, this would be $200. The tips withheld plus an equal amount would be due to the employee. So you're not going to, the employer is not going to win. The recent
Yeah.
changes also provide clarification and examples of when a manager or supervisor is allowed to keep tips.
Interesting. Okay, so the penalties kind of are pretty severe on this. Yeah, it's double the amount of tips that were initially withheld, plus some pretty decent fines on there for each
Sure.
violation, right? Yes. So if there's multiple violations, that could really add up quickly.
Sure can.
Tons of questions to follow up on because I know it's all going to come down to legalese and those kinds of things. How would you define what is willful in this, and how would you define that for someone who's asking these questions?
Good question. So, a willful violation occurs when the employer knew or that's the important word, or showed reckless disregard for whether its conduct was prohibited by the FLSA. So, I know you're going to ask when they know what's reckless disregard, so I'll go ahead and just answer that. So, an employer knew, for example, and these are just examples, I'm not a lawyer, an employer would have known if they have received advice from an agent of the Department of Labor to the effect that the conduct in question is not lawful. So basically, if someone told them, right, if someone from the Department of Labor told them, that makes sense. An employer shows reckless disregard when they fail to make adequate inquiry about the conduct being compliant with the FLSA. So I think that's the big one, because taking somebody's tips, if you're not going to look further into the law to make sure you're doing something correctly, that is definitely reckless disregard.
I guess that sort of makes sense. Sure. Let's talk about impact to clients here then. Are any clients allowed to retain a small percentage of credit card tips to cover the process fee on those tips? So this would be considered a portion of tips, I suppose. Would you still be able to retain a portion of that to cover the processing fees?
The way that I understand this, yes, there was nothing that changed with that part of the law that was not addressed in the 2020 tip final rule, and the Department of Labor's Field Operation Handbook still contains the section regarding tips charged on credit cards and the employer deducting those fees associated. So I believe that the states that could do that in the past still can. Of course, you have to look to state law to do that because most states out there have a law that bans that.
For my entire tenure here at RASI so far, over the last almost 8 years, we really spent a lot of time educating on the difference between tips and service charges with clients, as there's often a ton of questions on there. So I got to shift gears just slightly. I know we've been focusing on tips, but would a lot of these things focus or pertain to service charges as well?
No, a mandatory charge for service, for example, 15% of the bill, that's not a tip. Those charges are part of the employer's gross receipts, just like selling a hamburger, for example. And the sums distributed to employees from service charges cannot be counted as tips received, and they increase the employee's regular rate of pay and subsequent overtime rates. So,
Yeah.
service charges not the same as tips. So, not impacted here.
Gotcha. And now I did hear you also sneak in a line a couple minutes ago about when a manager or supervisor may be able to keep tips. So I know that there's got to be some language in there that would allow for that to occur. Let's talk through that one. When would that apply?
So the final rule clarifies that a manager or supervisor may keep tips only when the manager or supervisor receives tips directly from customers for service that the manager or supervisor directly and solely provides. Just to give you a little bit more, the final regulations reflect the reality that some managers or supervisors perform work for which they receive tips. I mean, that's the reality. But the final regulations need to ensure that managers and supervisors do not keep any portion of other employees' tips, because if it is not plausible to attribute the tip earned solely to the manager or supervisor, then that tip does not belong to that manager or supervisor. It just doesn't. Furthermore, an employer may allow a manager or supervisor to keep those tips and may also require the manager or supervisor to share some portion of the tips with all other eligible employees. Take, for example, a manager or supervisor that fills in for a sick server and they receive tips. They're stepping into that server shoes, they're earning the tips just like that server would. So that manager or supervisor should tip out the other employees the same way as all servers do.
Makes
Your
sense.
bartender, your busser, your food runner, for example. They should still receive their tips from that employee at that time, that server, manager, supervisor stepping into that role.
Sure.
And if there were any other tip pools, mandatory tip pools, that manager or supervisor should contribute to that, because all those other employees, their work does not change just because that manager is serving. So we know a manager or supervisor who serves her own tables may keep her own tips, for example. However, a manager or supervisor that simply runs food to a table is not eligible for part of that tip. And so, the moral of the story, a manager that receives tips can contribute to a tip pool, but can never receive tips from a tip pool, and can receive tips directly from a guest only if they solely provided that service.
Understood. Okay, so that's a good, pretty clear definition between the two. Yeah, go ahead. Sorry.
Absolutely. No, that's fine. I was just saying, there are situations where small restaurants, or even now big restaurants, where they can't find staffing, managers, supervisors are having to step into those roles, and they're going to start earning tips.
And it's great. I think that's a really good way to distinguish between that. And they would still be required to contribute to the tip pool just as anybody else would. That makes perfect sense to me. And if they're just assisting with running a successful shift, like running food or even helping clear tables from time to time, they're not eligible for retaining those tips. They're just doing their duties of managing a successful shift in the restaurant. So that makes total sense between the two.
You got it. Absolutely.
But you are saying that the manager and supervisory team members can contribute to that tip pool. So that's a good distinction.
Absolutely. Yeah. A manager or supervisor can always contribute, but can never, ever receive tips from a tip pool, because if you were receiving tips from a tip pool, how could you have solely provided that service? I mean, that's the tip pool is everyone's providing service, and they all get a pool from the tip. So that's just, those two things don't go hand in hand.
It makes total sense. I think I only have one final question, but I want to do a quick little recap before we get there. So, some announcements, and they basically struck some language from prior verbiage that allowed for kind of a better clarification of what is considered eligible for tip contributions and management teams. When did these rules go into effect, Brian Smith?
So this final rule goes into effect November 23rd of 2021. So right around the corner.
Right before Thanksgiving, we got a big update to the tip rules as they apply. So interesting stuff. Brian Smith, always so educational. I love these podcasts because I learn a ton. Thanks for your time, man.
You bet. Hope you have a good one.